otherwise Immaculate application form. Your date of birth is reflected as 2024.
Yes.
In fact, 25 October 2024, so you're not even born yet.
Yeah. Apologies, Chief Justice. It's one of those errors that you can't even explain.
Yeah, it happens.
Yes.
It happens. All right, let's get to it then. You studied at the University of Lesotho in the early 80s and obtained a BA Law in 1983.
Yes, Chief Justice.
What we called it a Roma.
Roma, yes.
And then you went on to do your LLB at the University of the Witwatersrand.
Yes, indeed.
And thereafter went to Georgetown in the USA to do your master's degree.
Yes.
Was that in labor law? That was the done thing those days.
Yes, it was given. It was in labor law.
Yeah, I did a master's in labor law and con law.
Yes.
Well, actually, around the same time that you were there, I'm surprised that you didn't get to meet. I wasn't at Georgetown part of 1990.
Oh, okay.
Yeah. Anyway, we'll talk about that outside this room. You have a long career in the field of labor law in this country, but then before you joined the legal field, you were a politician. You were executive mayor of some town for a brief period.
Some important district in the called the
Well,
Western.
the Western district.
Yes.
Indeed. All right. Then you joined the CCMA as the director.
Yes.
In April 2023 and remained there until 2025. Can you just take us through the ranks you went through to get here, just briefly?
Okay. Very quickly, that I went to the CCMA as CEO, spent a few years there. I then left. At the time, I was also serving as the chairperson of the Public Service Bargaining Council. In fact, I was assigned by the then CEO to establish the Public Service Bargaining Councils. That was part of my duties, and I served for 10 years as the chairperson of the PSCBC. And in the midst of that, I was then approached by the then Minister of Public Service, which doesn't appear on my CV, to establish an ombudsman's office in the SITAS, State Information Technology. Things didn't work out. There was a bit of resistance. People didn't support the idea. And I went back to the CCMA. In fact, it was just a coincidence. I went back to the CCMA and I met with one of the colleagues who have since passed away, who said to me, "What are you doing?" And I said, "Nothing." And he said, "I'll make sure that zone, as he said it, which was the JP then, contact you before you sleep today." And indeed, the rest is history. I ended up at the Labour Court acting the first time in 2000. And then I went back to act again. In the interim, I was doing a fair amount of arbitration, mediations, and some inquiries in various hospitals, in some of the incidents of violence, particularly in the East End, and at the same time also mediating those disputes. Yes, and then I went back then towards the end of 2006.
Yes.
I acted for one term, and the JP then encouraged me to then put in my name in the, I think it was the April interviews in 2007. And then after that, I served for 10 years at the Labour Court, and I was then encouraged. And I must also underline this because I think it's one of the things I would like to speak to later. I was then encouraged to apply because most of the time serving at the Labour Court, I, on an ad hoc basis, served almost like a DJP. I did most of the work that the DJP would have done. But because the law, the way it's structured, I wouldn't qualify to apply for the DJP's position. I then was encouraged that for you to qualify, you've got to first serve as a judge of the High Court. And the JP of the Gauteng, JP Mlambo, then invited me, and I did a short stint of acting, and then I applied and served another 7 years there.
Yeah.
And yes, after that 7 years, I applied a year ago almost to serve as a DJP, and I started my appointment started on the 1st of November last year.
Right. You were acting DJP from March last year until January this year and got a permanent appointment in February this year. When were you permanently appointed as DJP?
1st of November to 2023.
All right, that's not clear from here. Okay, but you've been acting as the JP there.
I have been acting as a JP since February this year, because the former JP retired on the 16th of January 2024.
Yeah. You know that court intimately. You've run it for a considerable amount of time. You know its challenges and its needs. Would you tell us just as concisely as possible what plans you have for it?
Yes. Well, Chief Justice, I'm not going to bore you with the details of the challenges of the court because I take it and I've looked at the transcript of my previous interview, and it details some of the challenges that I thought existed or that I'm aware exist at the Labour Court. But if I may start with some of the challenges, just briefly, we faced with a huge backlog of cases. When I joined, there was also a high number of delayed reserve judgments. We had a big problem with pre-enrollment processes, which impacted largely on allocating dates to cases that were already filed. We were faced with, well, this is something that has propped up recently with the issue of delay in filling in critical vacant posts such as the registrar. And the other bigger issue was the issue of facilities, particularly in Johannesburg and the Durban court, and I'll speak to those later, what I have tried to do since I took over office. If I may speak to the backlog, the backlog is influenced largely by, and somebody said that we suffer because of the success of the CCMA. There's a huge number of cases that comes from the CCMA on review. Related to that, just as the numbers, it's also the conceptual approach that has emerged in the labor market where almost every other arbitration gets reviewed in the labor court. And I think for quite some time, I've always wondered why that was the case. And my own personal assessment is that it's largely because of the system we use of review, which initially, for those who conceptualize the LRA, believed that the review process would be an unsophisticated, simple for lay people. It would not require too much of technical, legal issues, but it turns out that's not the case. Partly the problem arises because of the interpretation that we as judges have given to what the Constitutional Court said in the Sidumo case. Before then, the approach to reviews was governed by CAREFOAM, came Sidumo, which said basically that the test for review is reasonableness. I think we've opened the gates too wide, and that has resulted in this many reviews that comes to the Labour Court. I mean, if I may just say that if you look at the OCJ's annual report in 2022-2023, the Labour Court enrolled 3,500 cases. Now, when you look at what the attempt that we have made to address the backlog was introduced in 2010 by the then JP Mlambo when he agreed with the professionals to provide pro bono services. That process has continued till today, but was based on professionals availing themselves in the first term of the recess of the year and the last term of recess for on a weekly basis. Lawyers would avail themselves for that post. We have now extended that with the agreement we have with the Johannesburg Society of Advocates, their Labour Committee. We now have on a regular basis, every week, one judge acting pro bono. And that has significantly since last year, or since the beginning of this year, significantly helped us to address the issue of the backlog. We've not really dealt away with it, and I don't think, as I said, that we're going to be able to do it as long as CCMA continue with the way it works and the efficient way that it delivers out their awards. We've also recently had invited advocates from the Durban area to also assist. So we also have pro bono acting judges in Durban. We're hoping that after we introduce the rules which were passed by the Rules Board, which came into effect on the 17th of July, that it will assist in terms of limiting the volumes that we receive in as far as reviews are concerned. Your Rule 37, the new rules, requires that an affidavit in support of a review should contain only concise statements of the grounds of review. We're hoping that will reduce to some extent the workload. We've also introduced or participated in the rollout of the Court Online electronic system. And I think besides Gauteng High Court, we're the second court to implement that system. We've tested it by using it in urgent matters. So far, we've already had about 100 matters that went through that system. And we're confident that we should actually roll it out to all our other processes. It's shown that it can work very well. In fact, the initial plan was to have implemented it this week, this term. We were delayed by some training issues that we wanted to ensure, particularly when it comes to the issue of lay people, assisting lay people with the use of the electronic system. The issue of reserved judgments, one of the things I did when I joined was to focus on seeking to ensure that we sort out the delayed judgment. In as far as permanent judges are concerned, I can confidently say, I think but for one person who has had personal challenges, I think we've resolved that particular problem. The issue of spacing related to Johannesburg and Durban. In Johannesburg, for many years, since 2018, as far as I can recall, the JP has been pushing for an additional space When I joined, I took it upon myself working very closely with the court manager and solicited the assistant from the OCJ. We successfully managed to secure the 5th floor in Johannesburg. We have gone so far as finalizing all the plans. Everything is there, everything is ready. We're going to have additional 5 courts and additional 5 chambers. And we're also going to rearrange the office spacing. In as far as the issue of files, I think in my report you would have heard earlier in the earlier interview that I did indicate that things were in a crisis mode in as far as safety, health and safety relating particularly to the risk of fire. Managed to discuss and negotiate with the JP of Gauteng, who had secured a space in Nkangala in Mpumalanga, and we were granted a space, and we started moving most of the files. We're not yet done, but the project is moving on. The other issue that I would like to also put forward is the issue of access. When you read the Act, it's intended to ensure that everybody who's involved in labor matters have got access to the court, but the reality is that we only have 4 centers where we're operating from. We plan to ensure that we have our footprint in each of the provinces. We have started our discussions with most of the JPs. Particularly, I had discussions to revive what we started earlier on by the previous JP, which is Limpopo. The previous term, we had 2 weeks of motion proceedings held in the Limpopo High Court. I've had a discussion with the JP in Mpumalanga, where we also consulted with the practitioners in that province on how we can ensure that we also provide service in as far as that is concerned. In the Cape, the ADJP has started discussions, and we're looking at possibly setting up in the George area. I am told from people coming that area, from that site, that there's a fair amount of work or coming from that particular area. And also we believe with the introduction of the case lines, access will be made will be more enhanced with the court online, because people would be able to can register their cases from wherever they are. And in this regard, we plan making sure that we engage with the high courts and all the courts where there would be connectivity, that people who are in labor matters should be able to do so. Facilities, Cape Town, we have just recently extended the lease. The building is fine, everything seems to be doing well there. Kabeha, we operate from the High Court, and we looked well after there. Durban, it's an understatement to say it's a building not suitable for the purpose. It's a building that when I walked in the other time, I asked myself, why have we been so long in this building? If you want to sense a smell of bad poo, you can go to the Durban High Court. It's really bad. It's terrible. But be that as it may, we have engaged with the officials in the OCJ, and recently we went and met with apparently we have been offered a building occupied by the SANDF. We have already done an inspection on the building, and I'm satisfied that that building would probably serve a better purpose for our needs. Johannesburg, I've already mentioned the plans that we have. The other issue that confronts us, not confronts us, but which I believe would facilitate the efficient working in the administration section is that of appointing, we've already proposed the appointment of an office manager. We've also made a proposal for the appointment of a chief registrar. I don't think we'll encounter problems in terms of cost cutting because these are positions that we managed to combine certain positions to create them. The issue of shortage of judge is the biggest challenge that we have. If you look at the history of the labor court, when the court started, I think they had about 3 to 4 judges. In 2007, they increased the number of judges to 11, and I don't think there's been any further increase since then. The workload at the same time has significantly increased, and as I said, largely because of review and other extension of jurisdictional legislation. We've prepared a proposal in as far as that is concerned, and the delay in us submitting it, I had a discussion with the former Chief Justice Zondo about it, and we were about to take it to, he was going to arrange to take it to the minister, but the time was not on our side. But we've already prepared a proposal in as far as that is concerned, and linking it to the number of courts that we would be created arising from the plans that I mentioned earlier. Where we are in terms of that plans, we are actually waiting probably by the end of this week for the costs to be provided by the landlord, and looking forward to at least by middle of next year to take occupation of the 5th floor in Johannesburg. One of the other things that I did since joining was to engage with stakeholders. We've met various stakeholders across the country and some in a general national meeting. We've met with BLA, Law Society, SAULO, CCMA, and various others. In as far as, and we would want to continue, because one of the things that came from my engagement with the stakeholders was that it gave me an opportunity to share with them the difficulties and challenges facing the court, but also receive quite positive and constructive feedback from the stakeholders. Acting judges, we established a committee of 3 judges with the secretariat consisting of the registrar and 1 secretary who assist me in sifting through the appointment of acting judges. We've also developed a database, because one of the things that we've seen is that there's a challenge sometimes in terms of how you select your acting judges, and we focus mainly on delivery, on performance, and that database will help us as and when people put their names forward to act. I've mentioned the rules. We implemented the new rules in July, and they seem to be working fairly well. The Labour Appeal Court previously operated on judges that were largely seconded from the High Court, and they were appointed for a term of 10 years. Their term has come to an end in June this year. We have continued appointing those judges on an acting basis. But what we've also done to ensure that we develop a pool of new judges is that we have tapped into the capacity of the other high courts. And so far, from the beginning of this year to where we are, I would say we've already had 2 female judges from Gauteng, 2 male judges from the Eastern Cape. We will be having a female judge from Mpumalanga this term, and we would want to continue with that trajectory in terms of ensuring that we also have presence in the various courts, particularly that will assist us with the issue of cost, because our court does a lot of traveling. The other thing with the Labour Appeal Court, the former JP, just before he left, he advertised 4 posts of permanent Labour Appeal Court judges, which has now made the Labour Appeal Court more of a permanent court. What I have now done is I've prepared a memorandum motivating for aligning the terms and conditions of the Labour Appeal Court judges so that it's in line also with the legislative provisions, because the LAC, for all intents and purposes, and also as provided for in legislation, the court is at the same level as the SCA. Also, what I have done, and we hope to continue with that plan, is at the recent SAJA seminar, I met with a number of judges from the various countries neighboring us, proposed to them that we should possibly look at a seminar similar to what SAJA was running, which would focus on the labor law matters. And in that regard, we have finalized a concept paper with SAJA, which we should sign off probably by end of next week, and we would then distribute it to the other countries and see what their responses are, having agreed what we agreed. And we're also working with the ILO in as far as that is concerned, and ILO and SAJA has given us their full support. Training and empowerment, one of the issues which was raised in my interview was the question of what the Labour Court is doing about empowering commissioners. I had a meeting with the CCMA. We agreed with the director that the Labour Court judges will avail themselves for regular seminars with the CCMA commissioners. Unfortunately, that process took a bit of time before it could get off the ground. But I'm pleased to say it has taken off the ground. We had the first seminar about 2 weeks ago or a week ago. And also, in as far as training is concerned, my engagement with the practitioners both in Mpumalanga and Limpopo, there was an indication that there's a dire need to assist in training in the various provinces outside Gauteng, Durban, Cape Town, and so on. And we offered to do so. We have run the first session of training in Limpopo, and the whole idea is people were saying to us that once they can have a good understanding of what's expected by the court in preparing to litigate in the court, that will probably provide capacitation and increase the number of professionals that would assist in those areas. So broadly, Chief Justice, that's what I would say in as far as going forward. If I'm appointed, I would like to continue with finalizing some of the work that I have started.
Thank you very much, AJP Mlatlegi. That's a very positive vision / report you've just given us. And speaking for myself, all indications are that the LC is working extremely hard to improve its systems within the limited means available. And congratulations on securing the extra space for your courts, by the way. I'd love to know how you manage that. I have a sneaking suspicion that JP Mlambo would have been involved. I know he has a bag full of tricks when it comes to these things. But I just want to raise one issue with you. About your envisaged position of chief registrar. From what you said and from past experience, I'm assuming that you have to sacrifice existing vacancies for the creation of this one of chief registrar. How are you going to do it to avoid the budgetary cuts, as you said?
Well, one of the positions that we are not going to fill is the position of an interpreter. we're not feeling in that position because we believe we do have not enough, but we can probably sacrifice and cope, but we do need a registrar, a chief registrar. In the last interviews, one of the judges was interviewed about an incident relating to an urgent matter where there was a total confusion as to who was supposed to remove the matter from the roll or enroll the matter to a particular date. And when I went back and started investigating, I then felt indeed we do need a chief registrar who will take charge of everything that happens in the registry.
No, I fully understand the need you paint, but what I want to know is if sacrificing this post of interpreter may not prejudice your court in the long run. And I ask because in an analogous situation, high courts have had, and the SCA have had to give up posts to create, for example, the post of office manager to assist the head of that court in light of all the work that has arisen for heads of court. And while it may not be, you can do away with it now, how do you know that you may not need it in future? And it is a struggle to get all the approvals from Treasury, from the Ministry, and whoever it is, the Ministry of Finance, and all these stakeholders that we depend upon for fulfilling our posts at this moment.
Chief Justice, I hear what you're saying and I agree with it, but the reality is balancing in terms of cost cutting and the strategic needs of the court. One is going to have to take those risks, and I realize it is a risk, but it's a risk that I believe will assist the labor court quite significantly, because one of the things that I believe in the labor court is a bigger challenge is somebody to manage what is happening. I mean, and I pull this from having to take responsibility directly and personally when it comes to pre-enrollment. All the pre-enrollment matters filed, they have to go through my chamber. I have to sit down and go through them. And I think with the chief registrar, we would be able to coordinate in the affairs of the registry. So I accept your point that it is a risk, but it is a risk that I'm prepared to take, and hopefully the whole issue of cost cutting is not going to be with us permanently.
Yeah, no, of course you need a chief registrar. How would you cope otherwise? I guess I'm just disgruntled that the judiciary has to make these sacrifices when it is actually getting more and more and more work. But that's a debate to be raised with certain parties who know who they are elsewhere. Okay, I want to ask you about your knowledge of the law and the judgments you've written. It suffices to refer to the GCB's comment that the numerous judgments handed down by you during your career as a judge of the Labour Court, High Court, and Labour Appeal Court illustrate that the candidate has an excellent knowledge of the law, particularly labour law, including the constitutional aspects of labour law. And I fully agree on my own reading of your material. I endorse this comment by the General Counsel of the Bar. All right, on that note, I'm going to give Acting Judge President Savage an opportunity to put questions to you if she has any.
Thank you, Chief Justice. Good afternoon, Judge Molekile.
Good afternoon, Judge Savage.
My question relates really to the bottlenecks in the Labour Court with regards to backlogs. And we know that the LRA requires the speedy and equitable resolution of labour disputes. but the fact that serious delays are emanating from the labour courts in resolving such disputes has very serious consequences, not only for employees and employers, but it has very serious economic consequences for the country as a knock-on effect. So there's a wider need to try and resolve labour disputes quickly. Do you think that case lines and the rolling out of court online is going to be able to improve the situation? And to what extent? Or are there other important and rather urgent requirements that are needed to deal with the situation?
Yes. No, indeed, the electronic case management is going to significantly assist us in terms of managing the caseload, in terms of tracking down. One of the challenges that we have with the manual system, you don't know one moment how many cases have come in. So with that system, it should help us. But more importantly, for the judge president, it will give you a good picture. That's what is called a dashboard in that system. You will have a full dashboard as to where cases are, what cases have been allocated, track down cases that get removed and why they get removed. That, I think, it's the beginning of the whole of the assistance that we'll get from the usage of the case lines or court online, to speak the correct language.
And then I've just got a second question, if I may, Chief Justice. And that relates to reserve judgments, because that too is one of the areas in which we're experiencing bottlenecks, not only in the labour courts, but also in other courts around the country. And I wanted to know your view. There are certain courts in which they're making the reserve judgment list a public document. And what I wanted to understand from you was your view as to whether or not such a list is a public document, and whether we should, in fact, increasingly be making reserve judgment lists available, whether online or to the profession or in some other manner.
Yes, I thought my understanding is that the Chief Justice, the OCJ, releases a regular list of reserve judgments with the names of the judges once it goes beyond a particular period. So personally, I have no problem with that. I think all what need from my side, which is the strategy I adopted, was to seek to engage directly with the judges who are delayed to find out what could be the reasons. And there may be various reasons for why judgments are being delayed.
Thank you, Chief Justice.
Thank you very much, AJP. I'll get to you, Commissioner Yes. I'm informed by the Secretariat that the NETLEC representative has had to log off. He has a flight to catch, but gave gave an undertaking that their needs were taken care of because they had consulted with you extensively. So you know what concerns, if any, they have.
Yes,
do you confirm that?
I do. I confirm that, Chief Justice.
Thank you.
Thank you.
Okay. Was that a hand for questions, Commissioner Noties?
Yes.
All right, go ahead.
No, just to check, CJ, if it is permissible to proceed without them. Because I know you can't proceed without the minister, this and that.
The premier. That's what I inquired into, and I was told that since he had logged in and then had to leave
No. Because if the minister walks out now, despite the fact that she signed, we can't even start when we reconvene for a break.
No, don't go any further, Commissioner Malema. He's online.
Oh, okay, thanks.
Mr. Mkalip? Mr. Mkalip, are you there? Where did this man go now? It's usually the problem with non-members of the JSC. Mr. Mkalipi, are you there? Can you hear me? I can't deal with this. Mr. Mkalipi? Harriet, can you just call him on his phone? Wait. Is that him? He's just disappeared now. I don't know what to make of this. I propose that we adjourn momentarily while the secretariat tries to get hold of him again, because he does pick up his phone, and he is not a flight, that we know for sure, because he's talking on his phone.
The President, acting on the advice of NEDLAC and the Judicial Services Commission, after consultation with the Minister of Justice and the Judge President of the Labour Appeal Court, must appoint the 3 judges of the Labour Appeal Court referred to in Section 168(1)(c). And then subsection 2, the Minister of Justice, after consultation with the Judge President of the Labour Appeal Court, may appoint 1 or more judges of the High Court to serve as acting judges of the Labour Appeal Court. So there's no provision that they must participate in the interview of the JSC, but they must give their advice to the President.
Which has been done from AJP?
Chief Justice, the further provision is Section 153 of the Labour Relations Act, which reads, Section 153(1)(a) reads, similarly, the President acting on the advice of NEDLAC and the JSC, provided for in the Constitution, in part, and after consultation with the Minister, must appoint a Judge President of the Labour Court. So 153 relates to the appointment of the Judge President.
Yes. No, thanks for that. Commissioner Jess, you raised your hand.
I wanted to point out that I think commissioners, even new Chief Justice, no member of NEDLAC has been part of the JSC. But in the interview, they would be consulted. I'm sorry, in the selection process, they were never set in the JSC. And if you go to the Constitution itself, the composition of the JSC is set out there. That is, the JSC at all times is either 23 members or 25 members. So it would mean now, if we say we add the members of NEDLAC, they must vote, they must, we can't have that particular provision. So the interpretation is correct, the section is correct, they must be consulted. That's all what is required. And if there is one instance where they said at the JSC, somebody can point out when was that.
Thank you, Commissioner. Yes. Yes, JP Mlambo.
Thank you, CJ. Just a slight NEDLAC representatives have sat here, but not as members of the JSC. It's more of an observing role of sorts. I don't know what the basis is of that. That's how it's always objected or operated. And they've never voted. That tells me that they are not members of the JSC.
Do they get to vote?
No, I'm saying they have no vote.
They have no voting right.
They have no voting right. They have never voted.
All right.
Yes.
All right, then. Commissioner Malem?
No, I don't have a problem. I was just worried that we must not make a mistake. But it seemed correct to say NEDLAC didn't sit here. And he knows that he's deliberately trying to mislead us. That's why he says, if I'm wrong, someone will remind me. They are always here. They occupy the seat that is occupied by the Premier. When the Premier leaves during provincial division, and then it happens that Labour comes, they sit there. So if we are good to go, let's go.
The relevant provisions of the Constitution and the Labour Relations Act seem to give us a clear answer, Commissioner Malemo, that they need not be here, as long as the consultation, which I would presume can take place even after the interview itself has happened. So I think we're covered.
The only point I want to correct, I'm not misleading. When I'm saying sit, they have never sat as members of the JSC. That I repeat.
They are observers.
They are observers,
All right.
they can come, but they have never,
All
that's
right.
what Judge Member is saying as well. So I'm not misleading. Commissioner Malema must correct that. It's unfair to say I'm misleading. You know.
The record will speak for itself, Commissioner Nuches. I'm not prepared to waste any further time on the developing spurt between the two of you. We have a candidate to be interviewed. Commissioner Ngaitobi, you wanted to add something?
No, I just want to Chief Justice whether you shouldn't. The NEDLAC representative was here,
Yeah.
and then left. It might be that we resolve to proceed in their absence, because you never know with these things of composition whether the way it was composed at the beginning has an impact in the way it's composed in the end. But although I think the correct legal position is that we are good to go, it might be that we say we've passed a resolution unanimously to proceed despite their unexplained absence.
Well, he's still online. I don't know what I see his name on screen. I don't know what that means. I don't know what that means.
And Chief Justice, we have put on record that they have provided the advice to the acting JP.
Yeah.
Which she's aware of, yes.
We had that report at the outset that they had consulted with the JP and AJP and gave an indication of their concerns, if there were any concerns to her. All right, but perhaps for the sake of completeness, we should formalize it and make take a resolution. We have a motion from Commissioner Ngaitobi, as I take it. Who seconds it? Thank you, Commissioner Pillay. So we'll proceed without the NEDLAC representative, who appears to be still logged on, whatever that means. All right. We go back to the candidate, and apologies to you, Judge Bulatlehi, for this. It's not our fault. It's not for our doing.
No,
and to everybody in the room.
that's fine, Chief Justice. Thank you.
Okay. Do you have questions for the candidate, commissioners? Commissioner Mangen?
Thank you, Chief Justice. Good afternoon, Deputy Judge President Mulashe.
Good afternoon, Commissioner.
I've got a question in relation to the reserved judgments. In your response to the question by Judge Savage, I did not get an impression that you've got a tool to deal with or to manage the reserved judgment in your division. And it's a point of concern for me because in the Labour Court we are told labour matters are urgent matters. They can't be urgent matters for litigants and not be urgent matters for judges insofar as delivery of judgments is concerned.
Okay, my apologies if I didn't explain fully. We do have a system. Each judge has got a secretary. The procedure is that, let me start with the acting judges. At the end of their term, within 2 weeks from the time that they end the term, the secretary has to send an email reminding them of the reserved judgments. If nothing happens as it moves closer, second email is sent and followed up with a telephone. After that, the third email that gets sent will be closer to 3 months. I think it's after 2 months. If there's no response, it then gets escalated to my chamber. My secretary then follows up. If there's no response, it then gets issued by me as a directive now to say, you need to tell us when can we expect your judgment. And also what I will then do is to also contact the judge telephonically. With the full-time judges, I have sat down with the full-time judges and I worked out a system where, because when I joined, the backlog was very high. Worked out a system to start looking at the allocation and